I'm Sue Abrams with CLC.
I'm Dennis Smeal with LADL.
And we're so excited to see so many people in this room to talk about RFA, which is one of our favorite topics. And we both get a lot of questions about RFA. The way we structured this presentation is Dennis surveyed some of his attorneys, and we had a list of frequently asked questions. The first being, what is RFA? So that's where we started from, but we tried to turn those frequently asked questions into a training, but we are very happy to be interrupted if you guys have additional questions that aren't covered in these slides. So, starting, where do I point this? Do you know?
Hey Sue, what's RFA?
I don't know how to...
It's not turned on.
Oh.
Let me.
Yes, thank you. Oh, on. It looks on. Okay. All right. Awesome. Okay, so our first frequently asked question. What is RFA? Wait, I thought that was ASFA. Is ASFA dead? So RFA, on the next slide, is the new approval process to approve a home for, so here's where it gets tricky. Are we approving the home for placement, or are we approving the home for funding? I think some of these areas are still a little gray. We don't have, there's one case that came out of San Diego on RFA, and it had to do with Minors Counsel getting access to the RFA paperwork, but it doesn't have to do with this particular issue. So we still don't know all of that, but what we do know is that it is replacing ASFA. It's the new approval process in California that replaced ASFA. So you can assume that what we use ASFA for is now what we use RFA for. Does that make sense to everybody? It's also supposed to be, and the reason, so just a little quick history on RFA. So they put RFA in the code and legislation in 2007 as an option for counties. And exactly 0 counties opted into RFA, and so 5 years later they made it mandatory for the whole state. So that's kind of the progression. And the whole point was to make it be one process. So everybody has the same approval standards now. So before we used to have a process for relatives and non-relative extended family members, and we used to have a process for licensing foster parents, and then we used to have a process for guardians, and then we'd have a different thing for adoptive parents, right? So we had all these different assessments, and so they thought, let's just do one process. It's going to be one approval, and it's going to be good for all of those things, and it's going to be good for every child. So as opposed to before, where you had to get an approval for each child that was placed with a relative, this is just it. You get RFA, and then you're approved for everybody, and you're approved for everything. So that was kind of the intent of RFA. And the intent is for RFA to replace ASFA.
And you guys are all experts in WIC 300 and 200 and 300, and you got that down, but this is WIC 16519 and .5. And you should be familiar with that. It actually is fascinating reading. Seriously, I'm not joking. That is good.
Okay, so when do you use ASFA versus RFA? So the weird thing is we're still not all the way to RFA. So we're kind of in this period right now where you're seeing both of these approvals. But for any prospective caregiver, after January 1st, 2017, they have to go through RFA. So everybody new goes through RFA. ASFA comes into play with prior approval. So for any caregiver who is caring for a child before that time, their ASFA approval is still good right now until they have to convert to RFA. And that has to happen. They have to begin the conversion process by the end of next year. And this keeps getting extended. But I know LA County has started. They have thousands and thousands of families. So they have started this conversion process. But until then, those caregivers can have their ASFA. Their ASFA works as an approval on their home for funding, and then every year they have to go through an update to approve their ASFA, and that's good until they convert to RFA.
Hey Sue, what if they're in legal guardianship?
If they're in guardianship, if the case has been closed, if jurisdiction's terminated, then their ASFA approval is good. That's the approval that's going to be in place. If we file a 3D8 and reopen the case, they're probably going to have to do RFA, right? Unless we reclose it before the end of next year. If we want to terminate jurisdiction into a guardianship, until that time, until 12/31/20, we can use ASFA. We don't need to use RFA. So I think this might be a time to be strategic on cases, because we are seeing some cases convert And as they're going through conversion, they're getting denied. So these are homes that have had kids in them sometimes for years and years, 5, 6 years, and they have had this ASFA approval in place, and then they go through RFA, which is much more invasive, a lot more questions, they're interviewing a lot more people, and then they decide, even though there was never any risk to the child before, that they can't approve RFA, and they're getting denied. So as we're going through this conversion process, it's important to look at cases and say, maybe this is a good case that we should terminate to guardianship before they have to do the conversion process. We might also just want to do it because the caregiver might not want to do the conversion. We've heard some caregivers getting pushback because they ask a lot of questions about everything, their mental health, their personal lives, and so some caregivers just really don't want to go through that process. So it might be something you might want to look at closing the case before they have to convert. Any questions on that? Awesome. Okay, this is just kind of because the question was what's RFA versus ASFA, this goes through a checklist of the different things that they looked at for each of these different assessments, and you'll see RFA asks for all of them, so it's just very intensive, but it's just a little chart for comparison. Okay. You gonna do the question?
No,
Or do you want to? Okay, so the next frequently asked question was, what is required for RFA? So for RFA approval, this is kind of the big overview. You have to receive an orientation, undergo background checks, and then you have to do 2 assessments. One is the home environment assessment, where they're actually looking at the grounds of the home, and that looks a lot like what ASFA used to look like, right? They're making sure the safety bar is all open and that there's the pool's, you know, not accessible and things like that. And then you also have to do what's called a family evaluation. They used to call that a psychosocial, and that looks a lot like what our old adoptive home study looks like. So that's really a much more in-depth look at the family, interviewing every kid in the home, interviewing the caregivers, letters of recommendation. So those are the 2 big pieces of RFA, the home environment assessment and then the family evaluation. We kind of talked about this. This is the family home environment assessment. Again, looks like ASFA. This part at the bottom, total number of children can't exceed 6. This comes up a lot, right? Because we have siblings, we have relatives who are caring for their own kids, and then other sibling groups. There are exceptions in the written directives that are new that allow for RFA to be approved even for more than 6 kids if it's either to keep a parent and a child together or if it's to keep the siblings set together. Any questions so far? Yes.
They must be declared as siblings set to meet that exception.
No, they don't need to be declared a sibling set. It just says to keep siblings together. It's the language is pretty broad in the written directives.
Would you say that there are a lot more exceptions now than there were before?
There are a lot more exceptions now. I think the county has not wanted it to be as stringent as it has been because of the way the law is written, and so there's been several iterations of the written directives, which are the rules and regulations for RFA. And the most recent one had added several different exceptions, including, and we're going to get to it, but I'll just say it now, but including the ability for a child to sleep in a room with a caregiver. So that comes up a lot. Caregiver only has a studio, there's not space, or to keep siblings together, or to go past 6 kids if there's if the relative or NRFM is caring for their own kids and then also trying to take in other family members.
But interestingly enough, not a lot of exceptions regarding the pool and the pool being walled off.
That's new, yeah. That's a change.
So if you're trying to get placement with somebody who has a pool on their ground and it doesn't have a wall around it, you have a problem, and that problem probably is not going to be solved except by finding a different relative.
Here's some additional requirements. They have to go through a health screening, they have to do CPR, face-to-face interview with everyone in the home, personal references, DMV checks. So just kind of showing you how intensive this process is as compared to what we used to do for relatives and NRFMs. Yeah.
Who needs to complete the first aid and CPR certificates? Just the primary caregivers, like the applicants, or any adult in the home?
The applicants. And there's a lot of confusion. That's a great question, just because there is so much confusion about what parts of RFA only pertain to the applicants versus other people who are in the home or have substantial contact with the home. And generally speaking, the other people are only going to need to do that criminal background check, and not the rest of RFA. So common misconceptions about RFA. Dennis is going to start this one.
Okay. So, first of all, the people will say, oh, you can't place without an RFA. Is that true or not true?
Not true.
Exactly. And what do you, can anyone just shout out real quick what you need in order to get an emergency placement?
Nice.
Nice,
Mantra.
that's really great. RFA is going to be denied, so there's no reason to start the process. And oddly enough, one of the people we hear this from most often is social workers. And we've even seen it in reports. Is that true?
No.
No. If the RFA, now there is a kernel of truth here. And what that is that if you are denied resource family approval, then you have to wait 2 years before you can apply again. So some good-hearted social workers will say, listen, you guys, I can see that you're going to be denied, so if you withdraw your application, as soon as you correct this problem, you can reapply immediately. If you don't withdraw and you wait until you're denied, then you have to wait 2 years. Is that a fair assessment of the status of the law right now?
Yeah, and the written directives have an exception that allows people to apply. It gives the county discretion to process the application, even if it's before 2 years, if there's been a change in circumstance. So we had a case recently where a caregiver was married, or a family member of the caregiver had a non-exemptable conviction, and the person was on hospice in the house, and they still said, no, we can't, RFA is denied because you have this person in your home who has a non-exemptable conviction, even though they're on hospice. The person ended up passing away, and then they reapplied and said, there's been a change in circumstance now, and DCFS is going to process the application. So there are times where they'll do it before the 2 years, but generally speaking, if you get denied, they don't have to process your application for another 2 years.
So I'm happy to see so many ladles here because a lot of us think that's not our table, that's CLC. They worry about that, they handle that, but they are only as good as we are. We have to identify the relatives. We have to interview our clients and really get names of people who are willing to apply for RFA. If we don't identify the relatives, if we don't identify the barriers to identifying the relatives, then you're going to have that situation where relatives are showing up at 2 6s. And no one wants that. No one.
It's also better for unification. There's a lot of reasons. I mean, a lot of times keeps kids closer to parents. If the caregiver is the monitor, you're going to have increased visitation opportunities for the parents and the child. So I think this definitely is something that should be important to minors' attorney and parents' attorney.
So what's the key to identifying relatives who will apply for RFA? Rule number 1?
Talk to them.
Be curious.
Be curious. You have to be curious. You have to be super curious in that initial hearing. At the detention hearing, you have to be curious. You have to ask questions. You have to know that some of our clients do not want to identify the relatives because this is the first day in court. They don't really know what's going to happen. Maybe their kid's going to come home today. They don't want Grandma and Grandpa to know. They don't want Aunt Esther. They don't want her sister who married the rich guy and now thinks she's better than everybody to know all about this. They have their privacy, and your job is to break through that privacy. Because if you don't get it today, then the kids could get placed with foster parents. God forbid they could be placed in congregate care, which is another word for group homes. Thank you, Luciana. So you guys need to get this information. You need to find out, you need to pry, you need to get that relative on the phone, you need to ask them if they have a pool, you need to ask them how many beds they have, you need to ask them who all lives there, you need to ask them if there's any, a relative who spends the night there a lot on a frequent basis. You need to ask all those questions, and then you need to advise them to go down and apply for resource family approval. Does anybody have any questions about what to do at the detention hearing as far as identifying? Sir?
I just want to go back to the 2-year ban for a second, because my understanding from the written directives is that it's actually a 1-year ban for an RFA denial and a 2-year ban for a rescission.
Yeah, we have a slide on that. They actually just changed that in 6.0, so thank you.
Yeah, so I just wanted to clarify that.
Yeah, we have a slide coming up. But yeah, that was a good change also, and thank you for clarifying that.
Sure.
Any other questions on this?
I also want to just point out the other reasons we often hear: child will be sleeping in the same room as caregiver, not sufficient space, criminal record, caregiver's too old, caregiver's son comes to the house and has a criminal record. So these are all different reasons that we've seen in reports why they're saying we can't go forward with an emergency placement because RFA will be denied. And so I think that the key things to remember here is, first of all, whether or not RFA is going to be approved is not a kletscaki or a walkthrough. It's not part of that 309 assessment. So that's one thing. Like, we're not actually looking at that. And the second is they have to process, unless they've already been denied, they have to process any application that's submitted for RFA. So we don't know whether it will get denied until it gets denied. And there's due process opportunities for the caregiver. So there's no reason to stop the process before it's even started because somebody thinks it's going to get denied. Any questions?
And if someone is coming to you and saying, well, they won't take my application, then you just tell them, go online. You can go online, you can fill out your application there.
Yeah.
We used to be able to do corrective action plans
Yeah.
on physical. Is that still a possibility?
It's still a possibility. They're called DAPs now, documented. So they have CAPs and DAPs, which is in the written directives. CAPs are corrective action plans where if they find something wrong, they can fix it. DAPs are called documented alternative plans, and they're exceptions to the rules in the written directives. So like the rule says you can only have 6, but you can do a DAP and say, okay, for this home, we're going to allow 8 kids to live there so these siblings can be with their relatives. So you still have both of those options in the written directives.
So they can't flat out deny you if one of those applies toward approval? Or
They can still deny you if they don't want to do it, but you can either try to get an abuse of discretion hearing in our courts, or you can send it over to the administrative court because, to pick the very few things where this has improved upon prior processes, I would say one is there's very clear due process rights for the caregiver, as opposed to before with ASFA. With RFA, they have to get a notice of action saying they were denied, they have to say the reasons they were denied, and then you can refer it to the alliance who takes those cases to fight the denial in the administrative court. So they can deny it if they don't want to do the DAP or the CAP, but you can fight back with some of the ways that we have, either in our court or in the administrative courts.
I was hoping there would be some more questions, so there's one other point that I
Yeah.
wanted. Oh, yes.
Just so to get updated information, do we know whether the Alliance is taking these? Because
Adam's right here. Adam is the
How is
benefits
Putting me on the
guru
spot.
at the alliance.
We were definitely looking at those on a case-by-case basis, and, I think as everyone knows, we both have limited resources, and, it can be tough to take on. I wish I could take on all of those cases. I wish we had more of like a public defender model, and we just took on every single one of those cases. We just don't have the resources to do that, but for now, please keep sending the referrals over. Happy to look at it on a case-by-case basis, and if anything does get screened out, feel free to call or email me directly. I'm happy to speak to anyone.
Yeah, and also there's other,
Legal Aid Foundation, LAFLA, has taken some of our cases too, so there are a couple other organizations who will help out.
yeah. So if you're a CLC attorney, definitely, if you have an issue like this, come see us, and I don't know, if you're the point person for Ladle.
No.
Or I can be the point person. Okay. And Ladle, I don't have an answer. Okay, so.
I have one more thing.
Yes.
So ladle attorneys, what's going to happen at the detention hearing is you're going to have 2 kinds of objections often to parents, from parents to some relative, to Aunt Minnie, for example. You need to really take the time to talk to your client to distinguish between a problem where, Aunt Minnie has just been fed up with my alcohol use and we're not getting along right now, or a situation where Aunt Minnie has said, that kid needs to come live with me, you're not fit to be a parent, I'm going to get my hands on this child and you're never going to see that child again. In other words, bad blood versus interference with family reunification services. You've got to try to distinguish between the two when you're, encouraging relatives to apply for RFA.
Okay. The written directive, so we've made a lot of references to these. This is a link. I always say in my trainings, it's like the best 100 pages I've ever read, as far as regulations go. And Dennis just read them, and
It's great.
it's great.
It's actually really interesting.
It's actually got all the
Yeah.
answers that we get. Anytime I get a question in RFA, I go to the written directives, and it really does have the answers, and usually they're helpful and not harmful.
Here it is. It looks just like this.
So,
And it's got a great table of contents, and it really, for 126 pages of rules, it's pretty easy to find exactly what you need.
yeah, so we talked already about the DAPs, but also child-specific approval, so this was added a little bit later, but it does allow the county to approve a home just for one child, which I think gives them more leeway, because before, they were having to approve the home for any child. That's what RFA was meant to do. And we pointed out that there might be situations where this caregiver really can take care of a specific child and it makes sense, and there's a prior relationship, but the caregiver might not be, an elderly caregiver with health issues, with a teenager. Caregiver might be perfectly capable of taking care of that teenager, isn't gonna be capable of taking care of some young kids, so the county can make that child-specific approval. This happens way less than it should, but it is a good tool. If they're coming back and saying, oh, we don't think this is a good home because the caregiver won't get approved for RFA, you can say, well, we're asking to assess whether child-specific approval is appropriate in this case. And I saw a hand up somewhere. Did I talk too much? Okay. How long does RFA take? So it used to take a long time. The beginning of this process, like a year, everybody remembers what a disaster that was, and caregivers didn't have funding, and it really was a mess. This is where we're at right now. So we have, these are the approvals and withdrawals and closed cases and denials, and then Dennis
131 days.
is very excited to let you guys know that it is taking 131 days to
131
approval.
days, that's almost, like 120 days is what they're shooting for,
90,
right?
90.
Oh, 90 days.
Yeah.
So 131 days is really good. We're getting there.
And ASFA, you remember, used to be 30 days, so we're still 100 days more than we were before,
Yeah, well.
but we're getting there. What the law says is 90 days, so that's the goal, is 90 days. 131 days, so can a child be placed pending RFA? You all already said it.
Yeah.
Yes, right? So we have two ways that you can get a child placed. Emergency basis, which we talked about, which is CLETS, CACI, and walkthrough. And we're doing that all the time. There are thousands of kids in LA County placed on an emergency basis. And then the other is based on a compelling reason. And this allows for the child to be placed once the home environment assessment is done. So once you do what looked like ASFA, right, you do the walkthrough of the home, you check the caregiver's background, but you haven't completed the permanency assessment, that family evaluation. If there's a compelling reason, you can still place a child pending RFA. So that's a second option. I think the reason that they created compelling reason was really not for relatives or NRFMs, it's for other situations. So like if you have a child who has severe disabilities and there's a nurse saying, I'm willing to take this child and you need to get this child out of the hospital quickly, this allows the county to do a quicker approval of somebody who's not necessarily related, because they don't have that emergency option for someone who wasn't a NRFM or a relative. Does that make sense? So I don't know that we really need to be using this much when we have relatives or NRFMs, because we have this quicker process, which is emergency placement. Any questions? Awesome. Okay. So what is the exemption process? What's exemptable versus non-exemptable? How does an expungement impact this? So we handed out a memo that we wrote a few years ago. So CLC co-sponsored a bill,
It's a
SB
separate
213,
piece of
and the point of the bill was to try to make this process quicker and more relative friendly, and also not to hold up placement when it really didn't make sense to do that. So we wanted there to be more discretion. The bill started with a lot more discretion, like the court would have the ability to place even if they didn't have an exemption yet, but that unfortunately came out in the process of trying to get it passed. So where we're left with is this, and the basics are that there's kind of different levels in convictions. So first there's crimes that are non-exemptable, and that's according to federal law. So you're never gonna get an exemption for those crimes. Any kind of violent felony, it's just not an option, we can't give an exemption. The second is crimes that are exemptable after considering all of the factors listed in Health and Safety Code 1522. And so this is like the process that they always used to do, where they had to get all the information about a conviction and they had to get letters of recommendation. And that process can take quite some time, especially the older the conviction is and the more remote it is from California. So sometimes you have a grandparent who has like a petty theft conviction from Minnesota for 50 years ago, and it's virtually impossible to get all the paperwork around that conviction. And those were the ones that were taking a long time, which it didn't really make sense to do that. And so now you have this third category of convictions where literally all that DCFS needs to give the conviction is the criminal history. That's it. They can look at the paperwork and say, oh, grandma has a petty theft from 50 years ago. We're not worried about that at all. We don't need any paperwork about it. We can just give the exemption. So they have the discretion to do that. They don't do it as often as they should, but they have the discretion to under the law. So you can always ask, you can always get a court order if you're dealing with a case like that, where you ask the county to consider giving an exemption based off of this simplified exemption process. Any questions on that? And the memo that we handed out, it actually lists the conviction, so you can go through it with a prospective caregiver and figure out, like, are you going to need to, can you get a simplified exemption, or, you know, are they going to need to go through this bigger process? And then the last thing is the county always has the discretion to require that bigger process. So even if grandma has a petty theft, if there's other concerns about grandma, DCFS might come back and say, we're not ready to use that simplified exemption. We want to get the paperwork, and that's their right under the law.
If you can get your bench officer excited enough about this, you can ask them to have the social worker ordered in to explain why the exemption isn't being granted. And sometimes that works.
Okay, so what happens with emergency placement when you have this requirement, a conviction? And by the way, we didn't talk about arrests, but arrests are in there. For the most part, arrests actually don't require an exemption. So if you see something with arrest, the court can order the child to be placed on an emergency basis, even if they're saying, we want more information about this arrest. The only time the court wouldn't have that discretion if the arrest is one of the specific ones listed in the code related to child safety. So if someone like is, you know, the conviction was possession of child pornography, you probably couldn't get a simplified exemption on that. But any other arrest, sorry, it's a conviction, but arrest. But any other arrest, you shouldn't need an exemption for. So how does emergency placement work? So the law says a child can't be placed if there's a non-exemptable conviction. So remember, this is an emergency placement. So what happens after it's an emergency, I think, is still gray law, whether the court has discretion to place, even if there's a non-exemptable conviction. But in terms of emergency placements, the court cannot place if there's a non-exemptable conviction. That's in 361.4. The court can place for any other conviction once an exemption's been granted. So you don't need RFA, you just need the exemption. Does that make sense? Don't need RFA. That's a big misconception, that they need to wait for the full RFA process to be done if there's a conviction. All they need is an exemption. And also, a child can be placed pending an exemption if all the parties are in agreement. So the court can't make that, the court can't order that, but it can happen if all the parties are in agreement. So they don't even need to get the exemption. They can place pending an exemption if everyone's in agreement. Any questions?
So can you clarify
Yes.
who's actually issuing the exemptions versus the RFA?
That's a good question, and it's different in every county, but in LA County, the way it works is there's an exemption unit that is within the RFA unit, which is why it gets confusing to line social workers sometimes, because they think, okay, because it's in the RFA unit, you need full RFA if you have a conviction. But actually, you just need an exemption, and it's within that unit. So they have their own unit, and those workers actually really do understand when they can do a simplified exemption. So you want to make sure, if the report's coming from like the ER worker, they may not actually know all this, and they might need to contact the RFA unit. And so you can try to make that happen in court and just make sure that they get the right information. Any other questions about convictions? Okay. 131 days. So that's a long time to not have any funding. And so for the first year or two of implementation, we didn't have funding, but thankfully the legislature changed that. And so now we have emergency caregiver funding, and it goes back to the data placement. If a child's been placed on an emergency basis and they've submitted the RFA application, and then the county has to submit the EA application, then the funding should go back to the data placement. And it's the basic rate, so they should be getting funding for all the kids in their home. Any questions on that? Okay,
Question.
yeah.
Is it always considered an emergency placement if you're trying to get them placed with a relative, even if it's not right at the start of the case?
Yes. So it's, yes and no. I don't think that's clear, and we tried to suggest language that would have made it more clear, but they wanted to continue to use the word emergency. What's weird about emergency placement is it can be pre-dispo or post-dispo, like LADCFS put in their policy that you can do emergency placements at any point in the case. So it's not quite an emergency, but it means that you don't have RFA yet, right? Yes.
To do emergency placement post-dispo, does there have to be a change in placement required? Like they're looking to change the placement of the kid?
So they definitely have to assess for emergency placement if a child's going to be moved. The same requirements of 309 come back whenever a child's moved, no matter where you are in the case. So if a child's moved post-dispo, 361.45 says you have to assess any relative in the same way that you did pre-dispo with Kletz, CAC, and walkthrough. So that's clear that if there's a change in placement, you have to. If there's not, it's not clear in the law. So it's not clear in the law, but the way that LA County has interpreted it is you can do it at any point in the case, and they put that in their policy. So
If a relative comes forward and post-dispo, you can use emergency assessment?
many do.
Okay.
And I don't know that it's clear what it says in their policy is that it can happen at any point in the case. So, I don't know that they put it clearly in that, like, those same terms, you can do it at any point, but I know that that's what their policy says, and then we have countless situations where the county has allowed for emergency placements using Kletz, CAC, and walkthrough, post-dispo, even if the child doesn't need to be moved. Make sense?
Yeah.
Yeah.
Really, for the emergency caregiver funding,
Yeah.
do we have an idea of how long it takes to kick in?
So it should.
So
Do you have-
you need to have an RFA application signed and an EA application signed by a social worker. Until those are not signed, you won't get it. It also goes through the DCFS process. It takes about a month, but the money should date back to the date of placement, not of the application being signed.
Any other questions? Okay. So what happens with placement if RFA is denied? So this scenario has come up many times now because we have a child who's placed on an emergency basis, the child's in the home, then they do RFA, and the caregiver is denied. Or we have the conversion situation, which we were talking about before. Ask for approval, the kid's been there for many years, they're looking into conversion, and then RFA is denied. So now what do we do with the placement? Wish I had all the answers, and I don't. That's the first thing I'll say. I think this is still a very gray area. I think we have some case law with ASFA that said the court doesn't have to remove. And so we have been applying that, CLC has been arguing in the situations where we don't want the child to be removed. We've been arguing that RFA doesn't require removal. Nowhere in the law does it say you need RFA to remove. You need RFA for funding, it says that, but it doesn't say, you need RFA for placement. So it doesn't say that the child has to be removed. So that's the position that we're taking. I don't know if you have anything to add in this.
No, I mean, unless minors counsel wants the kid removed, in which case they do sometimes argue against that. So again, make sure you've read the case law, make sure that you can make these arguments yourself, and make sure that you're not leaving it all up to minors counsel to do the work.
And we've also seen, we have several situations, several actual cases where the court has put in do not remove orders and they haven't removed the children even if RFA was denied. So that's kind of the trend that we've been seeing. Also, there's, if your caregiver is planning on appealing it in the administrative courts, that's certainly another reason why you might not want this child to be removed, because if they're removed and then RFA is approved and then there's resource family approval and then the child sent back, that's a lot of unnecessary removals and transitions. Any questions on placement? Sorry, and I said what we do know, and these are some cases that all are under the old ASFA approval, but in Re Cheryl M, there's no obligation to remove because nothing in the statute limits the court's discretion to leave a child in a home when an existing license is revoked. So again, this isn't exactly on point because it's not about RFA, but I think if we're looking at RFA and ASFA, similar things, then this case would be applicable. And then there's some other case law in Re Miguel E. Whether or not the county approves a relative's home is one factor for the court to consider under WIC 361.3. So this goes to the question of, well, if if there's a denial, if resource family approval is denied, can the court still order the child to be placed there? And so we're talking about the difference between approval and placement, right? And so if in Re Miguel E, it seems like that there might be discretion for the court to place even if resource family approval is denied. And then in Re ML talks about the criminal exemption, and that this is the case law that says the court can't order the department to give an exemption. That it's up to the department. The department has the discretion, the ultimate discretion of whether or not to grant an exemption. Okay, due process. So this is just the process for when a caregiver is given a notice of action, and they need to, so the notice of action will either be they're denied resource family approval or their resource family approval has been rescinded. We've seen both of these situations coming up, and so this is what needs to happen in order for them to appeal that decision in the administrative court. And if you have any further questions about that, Adam is much more knowledgeable than I am from the Alliance, and I definitely suggest using them as a resource because we found it very helpful, yeah.
Could you walk me through real quickly, because once in a while, we'll have clients that right at the arraignment are giving us directive that, they want the child to go to the relative and they want to do a 368 guardianship.
Yeah.
So let's say the child is placed under an emergency exception and we get them to the relative and we set a no-time waiver trial. So the child's detained. So within 15 days, we're looking at a possible dispo. And
Do they need funding?
If they don't need funding,
Yes.
can we just open and close the case right then and there?
They have to do they still have to do a guardianship assessment, like under 2.6, but they don't need to do full resource family approval right now. But they're not going to get funding.
Right.
So that's,
if the relative doesn't need funding,
Yeah.
and we have a client that's giving us directive, which we do once in a while,
Yeah.
that they want their relative
Yep.
to take legal guardianship, we can sort of
You can go around
collectively
RFA, yeah.
circumvent.
And if the caregiver is a relative,
Yeah,
they'll be
yeah.
eligible for CalWorks.
Yeah.
If they're a NERFM, they won't be eligible for anything, so they have to understand that. But if they're relative, they'll be eligible for CalWorks. And there's
CalFresh.
nothing that says that they need RFA in that situation, but they won't get funding because there's no
Sure.
process for them to
Sure.
get funding
Sure.
unless they're approved.
They would get funding as a NERFM though, under WIC 11401 and 11405.
Thank you.
Yeah, as a NERFM they would. even
For if you do a guardianship with no approval,
Uh-huh,
great,
yeah.
even better.
Yeah.
Adam's gonna join our training, so I don't get
Right, it would be
misinformation.
KNGAP to be state foster care. Yeah,
Even if it's not a probate guardianship,
yep,
great.
yeah.
Would it be a king
Right.
gap?
No, it would be
No.
state foster care, it wouldn't be KNGAP.
So if
Correct.
they're a
Only if they're
NERFM,
non-relative.
okay, even
Yeah.
better. So no matter what, they'll get some kind of funding. They'll either get CalWorks if they're a relative, and state foster care if they're non-relative, if you decide to go through 368 guardianship without doing RFA.
Correct.
Great. Yes.
But can a guardianship be assessed prior to disposition?
Under three, yeah,
Of course, it has to be under 368.
under 368.
Before our client even waives FR? If our client, because I believe the question was, if a client of ours is basically saying they don't want reunification,
Right.
they don't want their kid, and they're saying that they want their kid to be placed with a specific relative, the department can go ahead and get that ball rolling prior
Yes,
to waiving FR?
yes.
Okay.
Any other questions?
Actually, really quickly, I'm sorry.
Yeah, no.
How much funds could we tell someone if they're going to do a 360, and will they get comparatively to if they waited for RFA approval?
I'm gonna put Adam on the spot again, but CalWORKs, so if they're doing, it sounds like if they're NRFMs, they're gonna get the same foster care rate. CalWORKs is a much lower rate, and it's also not, it's like when you add kids, it doesn't double or triple the way foster care benefits, it's a smaller increment of an increase.
Yeah, that's all 100% correct, and there are no specialized care rates for CalWORK, so if you're caring for a kid with special needs, the rate doesn't increase.
Right. So you could be talking about a difference of thousands of dollars a month.
Yeah, but for the non-relative guardian, it should be zero difference.
What about Medicare then for the kid, the medical care, all of that, is that Medi-Cal they get?
Yeah, they still get
That
Medi-Cal.
wouldn't be, I don't
Through
think that would
through
be
non-early,
affected.
Non-need care.
Any other questions? Okay. So how can we speed up RFA? Is there any reason why kids should be in foster care while RFA is pending? So we just talked about the ways that you can get a child placed pre-RFA, so the answer to the second question is no. But how can we speed up RFA? Unfortunately, there's not a whole lot that we can do. I mean, a lot of this is just county trying to get through a bunch of things that need to be done for resource family approval. But there is this toolkit that you can provide for caregivers, and it has like a step-by-step. It's something the Alliance put together, TLC helped, and a bunch of other groups helped. And it has a step-by-step overview of what needs to happen for resource family approval, and it helps the caregiver be able to start gathering whatever documents they're going to need, identify people who are going to give personal references and things like that. You had a question?
Well, I just want to make sure, does everyone here know what the Alliance is? I don't know, but we have some new attorneys here, so I just want to make sure everyone knows they're talking about the Alliance for Children's Rights, and they're a wonderful resource.
Yeah.
I just wasn't sure they were introduced.
Okay.
Yeah, so, hi everybody.
Adam should be up here.
Yeah, so we're a nonprofit public interest law firm, and basically we serve kids in foster care and who were previously in foster care holistically, and we do all of the extra courtroom work. So we're not representing in placement, we're not coming into the courtroom, we're not coming to Monterey Park, but we work on benefits, we work on education, we work on health care, we work on services for pay youth like identity theft, housing, etc. And you know, we partner with other organizations on policy. So.
Thank you.
Yeah, of course.
Yeah, so anyhow, this toolkit is also available in Spanish. It's a great resource, and it can help at least the caregiver kind of get ready for all the things that need to happen for RFA. Okay, so we have some hypos. But before we do that, does anyone have any questions about RFA that we didn't cover? Yes.
So I was once told that there was a DCFS or RFA worker here in the building to assist with RFA applications. I took a relative to the third floor to this office. The same gentleman was there, but he informed me that he's no longer doing the RFA applications, and he instructed me to go to the fifth floor. And then I went there, and no one answered the door.
Okay.
So are we still doing that in the courthouse? Where do we go?
Last we heard they were. But if you email Luciana anything like that, we can at least follow up. The person within DCFS who runs the RFA unit is incredibly responsive and helpful. And so if you have any kind of particular issues like that, email Luciana and she'll follow up with DCFS. But for now, we can send an email on that.
Perspective, or the prospective RFA applicants that you have that are computer savvy, that have access to the internet, the application is online and it's actually really simple. Like it's very basic information just to get the application started. So in some situations, it's even easier to sit down with them either with your computer or give them the website if you know they have access to it to do it on their own too.
But were they trying to live scan? Because if they're doing a live scan, they should be doing the RFA application at the same time.
No, she just wanted to start the RFA application, and she was having issues getting a hold of the worker to figure out where she was supposed to go, and I didn't realize the application was online.
Oh yeah, it's online.
So I was like, you're here, you came all this way,
right.
Let's just go do it. And the same gentleman who was there, who I had previously taken caregivers to before, he was the same person, but he was like, I don't do that anymore, it's on the fifth floor.
Okay, yeah, we'll follow up. Any other, I saw a hand over here. No, it's on my imagination. Okay. Okay, so these are some hypos. These hypos actually came from a more general relative placement training, so they might not contain everything we've talked about today, but I think they'll be relevant. So the first, Pam was removed from her parents, who claimed they had no relatives available for placement, but during the agency's family finding efforts, they find out there is a paternal aunt who's been searching for Pam. In the DISPO report, the agency mentions they found the aunt and she's been approved as a monitor for the parent's visit. However, there's been no assessment of the aunt under WIC 361.3, which is that relative assessment they're supposed to do for DISPO. And there's also been no assessment of the safety of her home under 361.4, which is deflects, khaki, and walkthrough. So what do you do in this situation? Anyone have any thoughts on what you would do if you got this case? Anyone?
Come on, LADL.
Order 361.4.
Ask for 361.4 assessment. Anything else? Awesome. So, ask for sanctions. Yes. Okay. So the first is you can request a 361.3 hearing as required under Isabella G. So there's case law saying that caregivers, relatives who are entitled to the preference have an absolute right to a hearing. They don't need to file 3D8. So if they want an assessment to be done of their home, they can request that, a 361.3 hearing. And then you can also ask that 361.3 hearing include an assessment of whether the child can be placed on an emergency basis pursuant to 361.4. So that's one option. You can ask for the child to be placed on an extended visit. And then at the 361.3 hearing, if there's no criminal convictions, you can ask that the court place pending RFA. So those are the steps that I would take. Okay, hypo 2, same facts, except in this scenario, the assessment comes back and it turns out that aunt has a 20-year-old conviction for petty theft. She explained she was arrested in her early 20s for stealing food when she was struggling financially. She had to complete community service, which she did, and has not had any contact with law enforcement since. The report states that because of this conviction, Pam can't be placed with the aunt until she is approved as a resource family. Is that correct?
No.
Awesome. So what do you think we should ask for?
What?
Say it again? The fast track exemption, yeah.
Yeah, but the worker already hasn't done the exemption, so.
That's what you request for, so that they don't say you have to do the entire RFA.
Right. So you can, my thoughts, request a supplemental report, address why the agency isn't using its discretion to place pending an exemption. So remember, if all the parties are in agreement, everyone's in agreement, you don't even need to wait for the exemption. You can place pending the exemption. So that's one thing. Also, why the agency is not using its discretion to fast track the exemption.
And the couple of times that I have asked the court to order the RFA worker in to explain why she hasn't approved the exemption or granted the exemption, it never, the RFA worker never came in because it was just miraculously approved by the time we came to court that day.
And the last thing is the status saying RFA is still pending should not be sufficient, and that's a lot of times what we do see when we're making these requests. So I think just making sure the court knows that there's other things that we can be doing to make the placement happen more quickly is very important, because a lot of, and this is, RFA is very new. I think a lot of times their bench officers don't really understand what's happening, hesitant to make these placements without RFA, so I think it's important that they understand the different options that are in the code right now.
And I don't want to gloss over that RFA is pending are words that we should not see. If you see them, you can argue that's an incomplete report and ask for the matter to be put over for further information about exactly what is going on with RFA and what its status is.
Okay, the last hypo, Sarah's 17 and resides in a group home. This is an actual case. Her case is post-permanency in APLA. She's been spending weekends with her grandmother, and her grandmother feels she shouldn't move in with her permanently. The group home isn't going to allow her to remain there anyhow once the baby's born. And the agency's indicated they can't place Sarah with her grandmother because she hasn't yet been approved as a resource family. Is that correct? No. Right? So this is the same kind of situation we were talking about post-DISPO. I think because she has to be moved from the group home, 361.45 kicks in, they have to look for relatives and they have to assess whether they can place on an emergency basis. So you could request a hearing pursuant to 361.45. And just a note, RFA doesn't change any obligation to assess relatives. So this was added to the code. It says this subdivision does not limit the county's obligation under law to assess and give placement consideration to relatives and NRFMs. And so that's why you don't want to see in reports like RFA is still pending, because that is not what the code says. The code says you're supposed to do assessments under 361.4, 361.3, 361.45, and you shouldn't be not doing those assessments because RFA is pending. So this is what we really want to distinguish between placement and the obligations around placement versus approval. That's it for us.
Questions? Really, no question?
Yes.
Did you guys cover the expungement, if that has any impact?
Oh, thank you. We
we
didn't.
forgot.
We put that in the, so if it's expunged, it shouldn't be a conviction anymore.
It's not a conviction?
Yeah. So that, and then, sorry, that's.
So that depends how serious the crime was, and then you treat it as though it was an arrest, and if it was super serious, the department's still gonna have to do some investigation about it. But if it's not, then you should be proceeding as though there is, nothing.
Right. And then also we have situations come up where the person's been convicted as a juvenile, and we've argued under the code it's not classified as a conviction, they call it something else. Remember, Robert? Stacy wrote yeah. So we argue that that's not actually a conviction. It doesn't require an exemption because it's not a conviction, and Health and Safety Code just says you need exemptions for conviction.
But again, depending on the seriousness of it, you're still gonna have to put up with an investigation, and the department does have the duty to do that.
Of the juvenile cases, we've been found the word is reported WIC 203, it actually says it's not a conviction.
Thank you.
Under any circumstance.
Say that again?
WIC 203.
WIC
Thank
203
you.
is, I'm sure, what we've relied on. Yeah, that says it's not a conviction, and so
It's an adjudication.
yeah, it's an adjudication, thank you. So we've been arguing that that doesn't require an exemption because it's not a conviction.
You know, a recent issue that came up for relative placement for me on an emergency basis is that there was a child welfare investigation that was either inconclusive or unfounded, and the court wouldn't place under 361.4 because she said that needed further investigation.
Yeah, and that's the problem, I think, with CACI histories is there isn't really, it's not the same, right? So if you have a conviction, it's very clear what needs to happen in the Health and Safety Code and in 361.4, but with a CACI history, it just says you do a check. So it's really kind of up to the discretion of the court, and I think that's, we don't have a lot of case law and we don't have a lot of guidance in code, so it's really just something we have to argue. I think it comes up, we've seen it come up a lot where we have the teenager who was removed in part because of the teenager's behavior, and then the teenager gets pregnant, wants the child to be with grandma, but grandma has a CACI history, and now, we're trying to argue that grandma's still a safe placement, we still want resource family approval there. We're seeing this come up for sure, and it's really, you can argue that the code is silent, and so it gives the court discretion, and just make sure that the courts are understanding that. Yeah.
Any other questions?
Awesome.
We
Thanks,
met
guys.
on time?
Enjoy the rest of your
Okay.
20 minutes of lunch.
Thanks.
Thank you.